Next, we have Teri Walters and Kim Walters versus Donald S. Falik. Good afternoon. May it please the court, Ronald Letterman on behalf of the defendant appellants. With me at counsel table is my partner and trial counsel, Keith Felty. I would request to reserve 3 minutes for rebuttal. So be it. And
you've been here all afternoon, you've seen how that's working.
I'm sorry?
I said you've been here all afternoon, you're seeing how that's working.
I know how it works in general.
You can attempt
yes.
to reserve.
Yes. Yes. As we were walking into the courtroom, my partner, Keith Felty, said to me that one of the primary reasons why we went to law school was so we didn't have to really deal with issues like chemistry and the periodic table. And here we find ourselves before this court in this very, very complex matter. The issues before the court are whether the trial court properly exercised its discretion in performing its gatekeeper function, in determining whether or not the plaintiff's causation expert's opinion was sufficiently and scientifically reliable in order to be admissible. The second issue is whether the Court of Appeals erroneously reversed the trial court's order and misapplied the abuse of discretion standard of review in doing so. It is our position that the abuse of discretion standard of review and its application to this matter is the first and foremost argument in this appeal. It is our position that the trial court went into painstaking detail the statutory criteria for determining whether or not an expert witness's opinion is sufficiently reliable to be admissible. It went through all the elements of the statute. It focused upon three of the most critical elements, in our opinion, and it did not abuse its discretion in doing so. The Michigan Court of Appeals paid essentially lip service to the abuse of discretion standard of review. It cited it as the controlling standard, but then the Court of Appeals itself went into painstaking detail in looking at all the different elements of both the statutory criteria and the Bradford Hill criteria for determining causation when it comes to issues of medical causation.
So this may sound like a facetious question, but it's not. So how would the appellate court determine whether discretion was abused unless it itself went through an examination of the evidence?
What it has to do and what it did not do in this case was determine whether or not the evidence that was cited by the trial court was sufficient so that the trial court acted reasonably, applied the proper factors, did not engage in any outrageous analysis that made no sense whatsoever. That is what the Court of Appeals should have done in determining whether or not there was an abuse of discretion. The Court of Appeals was confronted with a few controlling facts which really are undisputed here, and they really glossed over these facts in this opinion. First
Before
and
you
foremost,
get too much into the facts,
I'm sorry?
Stay in the theoretical first. So when you have novel areas of science, is there any guiding principle that should be applied in every case, or is it just simply up to that particular gatekeeper to review the evidence and make their best call? And if they went through a proper exercise, an appellate court cannot revisit that. In other words, 3 different judges or 4 different judges might each come up with different views.
That's correct.
And that's appropriate in your view under the laws that exist today.
So long as there was a reasonable basis to support the trial judge's opinion, then the abuse of discretion standard of review becomes very, very deferential, and the appellate court has to determine whether or not the trial court went beyond the facts of the case, went beyond the standards, the applicable standards, and made a decision that was totally unreasonable.
And that whole enterprise changes once there's actually been peer-reviewed study and scientists have weighed in on the science.
I'm sorry, could you repeat that?
I said that whole exercise changes when scientists have actually peer-reviewed this and they've weighed in and they've said, well, we think this is valid or we think it's not valid.
In a situation, yes, whether or not there's peer review is one of the elements, and it's a very important element, if not the critical element, for determining scientific reliability. And if the trial court accurately notes that there is no peer review and utilizes that as one of the factors, one of the 3 or 4 factors which would justify striking the expert witness, then that ruling has to be deferential. You go back to the Elher Court, the Supreme Court opinion that was released last year, the trial court relied upon 2 factors in striking the witness. One was the absence of peer review, and the other was the absence of scientific studies to establish that the community, the scientific community, engages in this sort of methodology in order to come up with that opinion. That was enough, because you have to utilize a deferential standard of review. These were factors that were part of the statutory factors, and the trial court applied those factors accurately. So even if the Court of Appeals or the Supreme Court in Elher or here would have weighed those factors differently, it being a close call, for example, that's not what the appellate court is supposed to do. The appellate court is not supposed to act de novo. It is supposed to give deference. It is supposed to determine whether or not there was a reasonable basis for the trial court's opinion and whether the trial court reasonably evaluated the statutory factors. If the trial court did so, then that ruling is not an abuse of discretion. So I hope that answers your question.
What was wrong that occurred here? We had a bona fide expert. We had bona fide peer review literature. We had scientific literature. What seemed to be missing was simply that there was a process of extrapolation from closely related, arguably analogous literature. What's wrong with that?
What's wrong with that is that the expert utilized the Sir Bradford Hill criteria for determining causation.
He didn't seem to say much about the Sir Bradford Hill factors, but if you say so.
De facto, in essence, that's what he was doing. And in the Court of Appeals' original opinion in this case, the Court of Appeals recognized that and cited the Bradford Hill factors as being the factors which controlled the analysis here.
But I guess my question is, isn't extrapolation essentially a kind of a logical principle, a logical application? We take something that's not exactly on point, but it's halfway between 2 peer-reviewed analyses, and we're trying to make some kind of generalized assessment in terms of new causes that may arguably be related to some kind of ailment.
The question is whether or not under the Sir Bradford Hill criteria or just utilizing the balance of the statutory criteria, whether or not you are allowed to analogize from an alleged association between a different chemical and the chemical at issue. I think that's what you are asking, is to what extent may an expert analogize? The Sir Bradford Hill criteria does not permit for that analogy in the first instance, because the threshold condition for applying the Sir Bradford Hill criteria is that there must be a strong statistical association between the chemical agent at issue and the specific disease. That is the widely accepted threshold condition that is utilized throughout the country.
Counsel, what if it's a circumstance that's just really obvious, but no one's like done a publication about it? Like, what if it's something that's just incredibly straightforward, but no one's bothered to peer review it because it's so straightforward?
That is such an abstract question. I wish you could give an example so that I could respond to that more specifically. But
okay. What if it's
arsenic instead of uric acid? It's arsenic.
Right. It's just something that's like really straightforward. Okay, let's
then
go
you don't
with just
need an
straightforward.
expert.
And if no one did peer review, nobody did they didn't publish. It's just straightforward.
If it's so straightforward, you don't need an expert. The need for an expert is defined in the court rules as whether or not it will assist the trier of fact and whether or not that testimony, that issue, goes beyond the purview of the ordinary layperson. In your very generalized hypothetical here, you don't need an expert witness because it's so straightforward. You don't drop a patient because that is a breach of the standard of care. That's what we learned 10 minutes ago. That is so straightforward, perhaps you don't need an expert witness. But in areas where you do need an expert witness, particularly where you're delving into the chemical basis of a causation.
Okay, I'm going to let you go on because I'm just curious. So when do I know when I need an expert, or when is it obvious, and when is it something that I have to require an expert for? At what point does this?
At what point, if you as a trial judge determine that this is an issue that is so straightforward that the ordinary layperson could understand it without expert assistance, then you don't need an expert, and an expert should not be used. Again, I go back to the most immediate example. You don't necessarily need an expert for the jury to understand that you don't drop a patient not only once, but twice. You don't need an expert. That's for the trial judge to determine based upon the facts and circumstances before the trial judge. We don't have that situation here. Here we have a situation involving causation, medical causation, between exposure to a chemical, a specific chemical, phosphoric acid, and a disease, Wegener's, for which no etiology is known. And that is very, very important, and that was one of the basis for the dissenting court of appeals decision and for the trial judge's decision, is that not only do you have an absence of even a statistical association given by independent scientific data between this chemical agent, phosphoric acid, and this disease, Wegener's, not only do you have that, but you have a disease for which the etiology is completely unknown. There is not a single piece of peer review, scholarly publications, testing, or otherwise, where an expert witness or a group of scientists has been able to say the etiology of Wegener's is X, Y, and Z. There is no etiology.
But it's the absence of the etiology, it seems to me, that warrants use of the Sir Bradford Hill factors. It's precisely that circumstance in which those factors are most relevant. All the Sir Bradford Hill factors require, as I understand it, is some prior connection or relationship that's sufficient to justify the application of those factors. In this case, that was thought to be the close connection between phosphorus and silicon on the periodic table, they each bearing certain kinds of chemical qualities in common. What's wrong with the extrapolation in that context?
I'll tell you what's wrong in general, and I'll tell you what was wrong in this case specifically. In general, the courts which have accepted the use of the Bradford Hill criteria do not allow as the threshold precondition an analogy. They require
An extrapolation.
They require an association, a showing of a quote-unquote strong statistical association between this chemical and this disease. If you don't have that strong scientific statistical association, you go no further.
Correlation is not enough.
I think correlation is too vague.
That's what I'm asking.
Yes, that's too vague of a word. It's not enough. Now, going beyond that to this case, where the plaintiff tried to analogize the sulfuric acid, or I'm sorry, the phosphoric acid to silica or phosphate, the trial judge, when going through the medical articles, made two conclusions, which again were subject to an abuse of discretion standard of review. One conclusion is that the plaintiff's expert just did not sufficiently analyze and proffer to the court a sufficient explanation of how close the analogy is between silica phosphates and phosphoric acid. That you need at least to have a strong showing so that whatever the molecular differences are, those differences would be irrelevant to this particular causation standard. The trial court said all that we had from this expert was a vague piece of testimony and a little snooty testimony, if I may editorialize, that silica and phosphorus were next to each other on the table, on the periodic table. Well, what does that mean? Could you get more vague? Could you get more vague regarding correlation, as you, Justice Wilder, asked about? No. You need a much stronger showing of an analogy, of a similarity in the molecular compounds of each element, of each different chemical in order to allow that analogy, if you allow it in any event. I say you don't allow it in any event because the courts which have adopted the Bradford Hill analysis require the strong statistical association between this agent, this chemical, and this disease. Secondly, the trial court, in reviewing these analogies, indicated that the medical journals that were cited by this expert, that what was contained in those journals was embellished by this expert, that this expert characterized the views within those medical journals as indicating a strong association with those alleged analogous chemicals. But the trial judge went back into those periodicals and saw that for silica, for example, there was a weak possible association, and for phosphates it was at best moderate. And the judge said, this is just too vague, the analogy that's being proffered is not strong enough, and the analogy in any event is being misrepresented and exaggerated by the expert witness. And those findings, again, have to be weighed under the deferential standard of view of abuse of discretion. The Court of Appeals did not do that. It de facto conducted its own de novo review. It did not determine whether there was any reasonable basis for the trial court's decision, and for that reason, we would request that the Supreme Court vacate the Court of Appeals majority opinion, reinstate the trial court opinion, and it could, if it doesn't desire to issue a full written opinion, it can most certainly adopt the dissenting opinion of Judge Meador at the Court of Appeals.
What would a full-blown opinion accomplish, in your view, if we were to think that that might be a worthy endeavor?
I'm sorry, I couldn't hear it at all.
What would be the purpose of a full-blown opinion if we were to consider going in that direction? What would we add to the state of the law in Michigan by doing such?
You would add a first analysis, a first impression by the Supreme Court with respect to what extent the Sir Bradford Hill criteria overlaps or is used in conjunction with the statutory factors under 4955, and whether or not Michigan will enforce the same strict condition that's enforced by the courts in the other states and in the federal jurisdiction, requiring a strict statistical association between this agent, not an analogous agent, but this agent and this disease.
Okay, thank you, counsel.
Thank you.
Good afternoon, Your Honors. Thank you for hearing me today. My name is Daniel Rucker, and I'm here on behalf of, and I had to do this the last time I was here. It's a little shorter than I am.
It would help.
I'm here on behalf of Kim and Teri Walters, and Dr. Gershwin presented a 100-page CV, over 40 years of experience in the area of immunology and vascular disease. He submitted dozens of peer-reviewed articles to the courts below, and he submitted affidavits indicating that he affirmed the analysis in the briefs below because I couldn't have written those on my own. He did precisely what any expert would do in this field. He looks for somebody who has suffered Wegener's granulomatosis, because that's how you know they have the genetic predisposition. Then you turn and you look backward. You look backward in a time frame for immunological onset. You look backward for something that, a chemical or a substance that the person has come into contact with that is sufficient to create this inflammation of the upper respiratory system that generates the onset of Wegener's. And that is peer-reviewed. The peer review articles, I cited Chen, my Exhibit 23, and Sibelius, my Exhibit 24, talk about the first step being this inflammation of the upper airways. And I was listening to the court's questions, and one of the questions was, we're looking at this analogy towards other things, pesticides, we're looking at particulates, fumes, things like this that have been that have shown statistically significant associations with the onset of Wegener's. And I cited those specific studies, Lane, Exhibit 25 to my pleadings, Hamadou, Exhibit 19, Exhibit 18. But there isn't necessarily a gap here. You don't have to look at these analogous studies, because if you know that inflammation is required, you can look at the safety data sheet. The safety data sheet that is published produced by the manufacturers of ultra-dense phosphoric acid says this will cause respiratory irritation. So I don't know how that correlates to being peer-reviewed, but it's certainly scientific. It's the manufacturer saying this will do the thing that the peer-reviewed articles say is necessary to create the onset of Wegener's, and that is inflammation of the upper airways. So he did exactly what they do in the field, too. And this isn't just limited to the Sir Bradford Hill method. I would point the court to the dozens of articles that I provided where the analysis is retrospective. They turn and look backward. They can't test. So they do turn and they look backwards, and they see what they've come into contact with. And he followed that procedure. It's a reliable procedure. It's a reliable method. He followed reliable principles. And this, I think, is part of what the Court of Appeals was focusing on, is principles and methods. When the trial court was looking at issues of, he was attacking the science, attacking Dr. Gershwin's knowledge of the science, rather than determining whether the science and the literature that he proposed supported his methods and principles. That's where the court has a duty to do de novo review. When you're not getting the standard right, when you're not interpreting the statute right, or you're not applying the statute right, there is a de novo review. And I think there are at least 9 ways that 9 fundamental aspects of reliability that the Court of Appeals pointed out. They're easy to find. They're the 9 points in my supplemental brief under the first heading. There are also 6 areas where the trial court fundamentally erred. Things where he misunderstood either the science or he questioned Dr. Gershwin's knowledge of the science, and then when you go back and look at these scientific articles, you can see it wasn't Dr. Gershwin who was making the error. It was the trial court. And the Court of Appeals had, where the trial court had a day and a half, he talked to us on the record. He talked to me through the transcript, but he said, I was working on this in the evening and I was working on it in the morning, and this is 700 pages of documents, and it's a lot to learn in the evening and the morning. But the Court of Appeals had several months to piece through this, and as you piece through it, you see that everything Dr. Gershwin was saying proved that he knew what he was talking about, and his reliability was there.
What about the statement about their proximity on the periodic table? Does that have any scientific basis at all?
I think what Dr. Gershwin was saying there is when you have silica, what he was talking about were two things, isoelectric focusing and electrophilic properties, and he studied different immunological disorders where electrophilic properties, as I understand it, means you've got an electron that is shared with other substances, and that can lead to that characteristic in a substance can cause the onset of these immunological disorders. So the fact that one substance has that characteristic and the one right next to it has that characteristic would be important. I think
so if they have the same number of electron shells, that's an important thing? Did he ever lay that out? Did he ever explain what he meant by that? And come down from the heavens to let us mere mortals understand it?
Well, I think, I don't think he was in the heavens, Your Honor, but I understand what you're saying. We tried to do that through our written product. We tried to do that in the briefing. We briefed the issue to the court, and then we moved for reconsideration. We tried to brief it, and he worked with me because, there is a lot to digest from a lawyer's standpoint that requires an analysis of the literature. And so we wrote very extensive briefs, and the court actually appreciated our help on that. But I think the issue of whether one's next to each other, that was just one example he gave. He also pointed out pesticides and insecticides, which are phosphorus-based chemicals. And he pointed out that this phosphoric acid is much more potent than...
Do you agree that an association like your opposing counsel was talking about is a necessary precondition to applying the Sir Bradford Hill factors?
No. When in Chapin, the court there was relying on an expert who said in the briefing and in the opinion itself, I believe, said that you don't need epidemiological studies to apply the Sir Bradford Hill methodology. That's about as far as I can guide the court on that issue, but he said we don't need these, and that was a nationally...
Did your expert apply that methodology, or did he just sort of say he did after the fact?
What he did was he applied, I think he did two things. He did the retrospective analysis. He did it exactly the way they do it in the field. You look, you find the person who's evidenced the onset of Wagner's, and you turn back and you look what they've come into contact with, what time period it was, whether it was occupational, how intense, what the duration of exposure was, that sort of thing. He did exactly what they do in the field. But with the Sir Bradford Hill methodology, that was something that we submitted to the court through our pleadings, through our briefing, both the brief in response to the motion in limine and then the motion for reconsideration, that explained to the court, yes, this also meets the Sir Bradford Hill methodology. And Dr. Gershwin signed an affidavit talking about things like confirming our analysis of things like strength of association, where you have these lesser chemicals that can cause the inflammation necessary to onset the disorder. And then you have this major, highly potent chemical that can eat away the strongest substance in your body, your teeth. There's just no comparison. And the doctors agreed with that. They said, yes, they admitted that this can eat away your teeth, and that's what it's meant for, so you don't touch it for very long.
Yeah, I don't think anybody contests the fact that it's a strong chemical and it was misapplied here. The question is whether it causes the condition that your client apparently has.
Well, I would again go back to that there are peer-reviewed literature, the Chen and the Sibelius articles that say that this condition starts off with inflammation of the respiratory system, and these chemicals that are of lesser strength or intensity or potency were sufficient, statistically sufficient, to cause the necessary inflammation in other patients. And so it's acceptable to rely on those by analogy the same way we rely on case law to apply it to a different fact. But we also have the safety data sheet itself, which says this creates inflammation. This creates irritation of the respiratory system. So I'm not reaching here. You have both a manufacturer's information and you have lesser chemicals that can do this, that can cause this inflammation. And we know that the pathogenesis of Wegener's is known and is accepted, and it's in peer-reviewed literature. And I would also point out that there is an example that I had thought about coming into this of a time where if you required peer-reviewed literature for every variable in an expert's analysis in order to allow that expert to speak, consider a mathematician. If you have two companies that are arguing over measurements, maybe a manufacturing product, and you want a mathematician to come in and testify to some computations, are you going to ask that mathematician to look for a peer-reviewed article with every computation, with these specific computations? No, you look at whether they're using the appropriate methods, the appropriate principles, and whether they've applied them reasonably. And if they have, then you shouldn't have to go back and look for a peer-reviewed article on every possible variable you can come to in the world. The variable here was that it was this extremely potent chemical versus some of these lesser potent chemicals, such as pesticides, which we find on our food, where phosphoric acid eats through your teeth. So I think in terms of the method and the approach, the expert used a couple of different approaches would satisfy the reliability standard. One is that he did it how they did it. They do it in the field. You turn and look backward. The other is the Sir Bradford Hill methodology allows for this analogy where you can't test. Sir Bradford Hill has to do with substances you can't test. It would be unethical to test here. I'd also point out that there's nothing in this literature, nothing presented by the defense here, that there's no literature or evidence that opposes Dr. Gershman's reliability. It's all argument. It's all suggestions that he shouldn't be believed. But the articles, as you go through them and as you have months and years to look through them, you find out that the man doesn't know what he's talking about, and he was reliable, and he is reliable, and the Court of Appeals was correct in finding that the trial court created too high of a standard. The trial court wanted proof in a motion in limine rather than looking for reliability, and there was plenty there to show that he's reliable. And in that short amount of time, I understand the trial court was doing the best it could. But upon further reflection in the Courts of Appeals and in the Supreme Court, you can see just how reliable he is, and I've tried to lay it out in my briefing as well as I can. Some of the things that the Court of Appeals did get right that I'd like to bring to the Court's attention, I already talked about the irritating to the respiratory system in the data sheet. The Court of Appeals underscored the intensity of the exposure, which is something that comes directly out of the scientific literature. Marr, Exhibit 18, and Lane, Exhibit 25, Duna, Exhibit 26. The intensity of the exposure here did support Dr. Gershman's reliability and his principles because he focused on intensity as well. And when you have something exposed to the person through their mouth overnight, there's an intensity there that can generate the onset of Wegener's. So he was looking at an appropriate characteristic when he looked at intensity, and the Court of Appeals recognized that. the expert looked at the time frame. There was 3 to 4 weeks between when Ms. Walters put the acid in her mouth and when the symptoms started onset. The Court of Appeals correctly acknowledged that that happened in the appropriate time frame, and that was undisputed that that was a correct time frame for an immunological response. Other things such as the high level of C-ANCA that showed in Ms. Walters is something that Dr. Gershwin testified to, and then it's shown in the scientific literature such as the Chen article at 23 and the Sibelius article at 24. So the court noted that there are scientific articles that show sinusitis as an example of an onset of Wegener's rather than as a cause of it. It's a byproduct. And there are a number of ways too, Your Honors, where the trial court simply misunderstood the evidence or misapplied it. The trial court thought that by looking to environmental factors that was too broad. But if you look at this literature, they're talking about things like farming products. They're not talking about a specific chemical composition of some farm product, because all you're trying to do here is find something sufficient to create that inflammation in your respiratory system. So they talk in terms of farm products and solvents and fumes. They're not giving chemical numbers for something. It just has to be something sufficient in that person to create the inflammation. Thank you.
Your time is up, Mr. Rucker. Thank you, Mr. Rucker. Thank you, Mr. Letterman. No, I'm sorry. There's no time left there. We stand in recess until January.